Ladies and gentlemen, let me first begin by saying how delighted I am to have been invited to speak in the Modern Advocate Lecture Series organised by the Queensland Law Society. The invitation is very much appreciated because in so many ways it feels like coming home. It is hard to believe that I left the solicitor's profession in August 2005. The last 13 years seems to have evaporated very rapidly. I was in no hurry to leave life as a litigation partner at Mitter Ellison. I enjoyed it very much, but the opportunity to exercise the judicial power of the Commonwealth of Australia, our nation state, and discharge the responsibilities of a judge within our society was a responsibility I simply could not refuse. It has been and remains a very great privilege. So I am pleased to be here amongst the solicitors of Brisbane and Queensland. I am conscious, of course, that not all invitations historically viewed are so much appreciated. Many years ago, the famous playwright George Bernard Shaw delivered an invitation to his old adversary, Winston Churchill, in the following terms: "Come to the opening night of my new play and bring a friend, if you have one." And Churchill replied, "I'll come to the second night, if there is one." Tonight I want to talk to you about some practical aspects of solicitors acting as advocates and advocacy generally. My remarks are really focused upon solicitors acting as advocates and advocates generally in superior courts, and in particular, of course, the Supreme Court of Queensland and the Federal Court of Australia. But these observations apply equally to appearances before the District Court. They also apply to appearances before the Magistrates' Courts and the Federal Circuit Court of Australia, although the dynamics at play in those courts are quite different. They are high-volume, long-list courts, and the pressure upon lawyers appearing before those courts is to cut to the chase as rapidly as possible because of the pressure of the lists. That, of course, is not such a bad thing, but the need to be disciplined, focused and efficient plays out differently in the other courts that I just mentioned. These remarks, of course, also apply to appearances before the Family Court of Australia, which, as we know, is in a period of significant transition under the announcements by the Commonwealth Government, and we'll see how that plays out, I think, in the not-too-distant future. In the 13 years I've been a judge of the Federal Court of Australia, I have only presided in 2 trials in which a solicitor acted as an advocate in the entire conduct of the trial. One corporations case involved a New South Wales solicitor from Sydney who, obviously enough, had a very particular kind of quasi-criminal practice, which seemed to me not particularly adapted to the kind of questions and issue in this proceeding. I don't say that disrespectfully, that was just the nature of the experience. But with respect to that gentleman, there were some features of the conduct of the case which left a lot to be desired. The other case involved a solicitor who was also from interstate, and the case was conducted very well. I have had many solicitors from Queensland appear before me in a very wide range of interlocutory applications, both contested and uncontested. Quite often, solicitors will appear on ex parte urgent applications for interim injunctions and related relief. However, solicitors very often appear in contested interlocutory applications in relation to such things as challenges to the pleadings and discovery and all manner of interlocutory applications in a proceeding, but also in relation to originating applications in a wide range of orders under the Corporations Act and other legislation. In particular, solicitors often appear in very important large-scale insolvencies and significant bankruptcy applications, and they're all very important matters. As you would expect, the quality of the conduct of those applications varies, but I have to say that in the main, the solicitors are doing a very good job, especially having regard to the things judges look for in the conduct of applications and a hearing for that matter, about which I'll speak in a moment. The first thing to say, however, is that the migration of solicitors into the role of advocates presents a real opportunity for the profession to focus upon an area of practice which calls for judgment, discipline, integrity and critical thinking. That's not to say that other areas of practice don't call for one or more or all of those qualities, but the litigation environment is a very particular application of those skills. It calls for a very particular relationship between the solicitor and the client. Litigation is an environment in which clients present the solicitor with a problem, not a transaction. Generally, the clients are stressed and tense because they need to pursue a claim against someone or they are responding to a claim against them. They are on the cusp of or in adversarial proceedings. The one thing clients in those circumstances want is to put the matter into the hands of a safe house. Every problem has a solution, and the solicitor undertaking the conduct of litigation and ultimately the advocacy of that litigation needs to be able to convey a sense of confidence to the client that their matter is in safe hands. I used to say to people, other than those involved in large-scale public corporations, of course, with general counsel where the dynamics are slightly different, but I used to say to them that they should try to have a good night's sleep because the matters which are causing them so much anxiety in issue can be dealt with, but I always used to reinforce to them that they had to stay with it and they had to see it through to the end. That is definitely not to say that the solicitor should fall into the trap of allowing the client's problem to become the solicitor's problem. The solicitor is a professional advisor who gives advice and takes instructions and makes forensic judgments about factual questions, the legal issues, and ultimately, in the context of advocacy, the focus and emphasis to be adopted in the case. The advocacy part of that equation presents great opportunities, I think, for solicitors to expand the role they play. It's a very exciting possibility. It does not matter whether in reaching this point in your life you have come to it from Gryffindor, Ravenclaw, Hufflepuff or Slytherin. The conduct of litigation, and particularly advocacy in litigation, is where the real magic happens. Before turning to some of the practical considerations, could I say something about the Federal Court of Australia? I suspect that most of the solicitors in this room and watching this presentation, when they think about litigation, they think about state courts, completely understandably. When I speak about federal jurisdiction at the University of Queensland and at the bar practice course, it is surprising to me the extent to which people think that the federal court spends most of its time addressing discrimination cases, human rights cases and native title cases. These are all very important areas of jurisdiction, especially for the parties, obviously, but nationally and in a sociological sense, they are very important parts of the jurisdiction. But the truth of the matter is that because of the amendments in 1977 to the Judiciary Act, the Federal Court of Australia was created as, ultimately from that date forward anyway, a very broad court of general commercial jurisdiction. I think this is little understood, actually. So to briefly give you an idea, in a preliminary sense, of the range of matters that I've been involved in personally, to give you a sense of the breadth of this, in the last 3 years or so, these are the sorts of matters that we engage with in the Federal Court. So I've been involved in 13 schemes of arrangement, which are the modern day, of course, form of takeovers, major large-scale insolvencies, such as the motorway failures and the toll road failures in Queensland and other places, giving directions to administrators and liquidators in the conduct of administrations, mass ASIC regulatory proceedings of many, many kinds, class actions such as the Wickham Securities litigation and Storm and Chentro, failed managed investment schemes in relation to aquaculture schemes and Polonia tree schemes, ACCC regulatory proceedings of every conceivable kind you could think of in all sorts of markets, joint venture disputes, especially in the mining industry in this state, tax proceedings of every conceivable kind you could think of, judicial review proceedings of many and varied kinds, including all of the famous challenges on the basis of jurisdictional error to Commonwealth decision-making, the regulation of financial service providers, bankruptcy, arresting bulk tankers at Dalrymple Bay and Hay Point, claims by the Commonwealth against the People's Republic of China corporations for remediation to the reef when a major ship ran aground on it, cross-border insolvency, intellectual property claims of every kind you could think of, references under the International Arbitration Act, and of course constitutional challenges, which we deal with a lot. So I just wanted to put into some contextual perspective the sweep of the sort of matters that we deal with in the Federal Court, which gives you an idea of the breadth of the advocacy scope that emerges. In matters in all of these areas of the Court's jurisdiction, I have had solicitors appearing before me in interlocutory applications and originating applications, and as I've said, in 2 full-scale trials. And this will give you some idea of the enormous scope and opportunity for the profession in engaging with our citizens in their legal affairs in this area of work. And it seems to me that these are areas where artificial intelligence isn't going to come up behind us and eat our arms and legs off. So this is an area of critical thinking. It's an area of great opportunity for making a difference with people. So let us now turn to some of the practical considerations. The first thing to remember about the role of solicitors as advocates relates to an aspect of the historical role of the bar. The great virtue of the bar over time has been, and remains, that the solicitors have been able to turn to the bar to obtain an independent view of the rights and entitlements of the client and take advantage of the specialisation in advocacy and the conduct of the trial by barristers. Historically, solicitors had the close relationship with the client. Members of the independent bar were just that, independent and at arm's length. Of course, they acted for the client, but generally speaking, they had no enduring relationship with the particular client, but merely a transactional engagement in a particular case. That is not so much the case today, as large commercial clients tend to want to retain the same counsel in a range of related litigation and often independent commercial litigation. Solicitors who conduct advocacy might be doing so as specialist advocates within a firm, but they are much more likely to be lawyers with the responsibility for the case generally and also appearing in the matter in the relevant applications or maybe in the conduct of the matter entirely through to trial. The first practical thing to think about is making sure that you continually try to bring fresh eyes and an independent mind to the proceeding and thus the representation of the client. Solicitors who conduct the advocacy in the matter as well as conducting the matter need to keep that idea firmly in mind. Independence is a very important notion. You all know, of course, that a solicitor representing a client in a matter before the court must not act as the mere mouthpiece of the client or of the solicitor instructing the solicitor advocate, and must exercise the forensic judgments called for during the case independently after the appropriate consideration of the client's and, where relevant, the instructing solicitor's instructions. A solicitor advocate will not breach a duty to a client and will not fail to give consideration to the client's instructions or those of the instructing solicitor where that's relevant, simply by choosing to exercise particular forensic judgments called for during the case, contrary to the instructions perhaps, where those decisions are designed to confine any hearing to those issues which the solicitor advocate believes to be the real issues, or where the solicitor advocate seeks to present the client's case as quickly and simply as possible, consistent with the robust advancement of the issues, or where the solicitor advocate informs the court of any persuasive authority against the client's case in circumstances where the client might be anxious about a solicitor doing so. As to the authorities and legislation, it is important to remember that at some point in the hearing, if the court has not already been informed of the relevant matters, the solicitor advocate needs to inform the court of any binding authority known to the solicitor advocate which he or she has reasonable grounds to believe to be directly on point, but which is nevertheless against the client's case, a confronting thing sometimes. Similarly, any decisions of an Australian Intermediate Court of Appeal should be brought to the attention of the judge together with the relevant legislation. That is not to say, of course, that points of distinction and differentiation ought not to be vigorously developed. Invariably, very real questions arise about whether a particular authority is binding or persuasive at all in all the circumstances of the case. However, distinctions without a difference must be avoided. The obligation to tell the court of the matters just mentioned does not arise, of course, if the opponent tells the court that the opponent's case will be withdrawn or the opponent proposes to consent to final judgment in favour of the client. A solicitor advocate might become aware of matters of the kind earlier mentioned after judgment or after a decision has been reserved for further consideration and while the decision remains pending. Whether the case in question or the relevant legislation came into existence before or after the argument was concluded, the solicitor advocate must inform the court of the relevant matter by a letter to the court copied to the opponent and limited to the relevant disclosure. Alternatively, the solicitor advocate might request the court to relist the matter for further argument in the light of what has emerged. The second thing to remember is that in order to be a good advocate, it is important to be a good lawyer. By that, I don't just mean talented or able or clever. I mean disciplined and focused upon critical thinking in the sense of making sure that you understand very clearly the legal principles which are engaged by the dispute or the area of controversy in which the client's problem lies. Put simply, this is the absolute foundation of everything. As the former Chief Justice of the High Court, Murray Gleeson, has observed, not all good lawyers are good advocates. But to be a good advocate, it is necessary to be a good lawyer. So focusing upon the foundational legal skills is an absolutely critical matter. And it might be a self-evident truth, but it is worth making the point. You might think that it goes without saying, but it is terribly important to take the trouble to try and master the principles of law relevant to the contest in question in which you are engaged and trying to serve the client's interests. This, of course, is also a fundamental duty of the lawyer to the client in any event. It brings me to the third thing to keep in mind. When you are acting for a party who is bringing a claim, the first important discipline is drawing a statement of claim. I am a great believer in the Chicago University view that writing is thinking, whether the writing is undertaken physically or electronically. The discipline of having to reduce something to a sequence of sentences forces the author to refine his or her thinking. When a statement of claim is being drawn, not only must the lawyer have marshalled all the relevant facts, but the lawyer must then isolate the material facts, which, if made good by the evidence, will make out the cause of action and the right to the remedy sought. I mention this threshold matter because the litigation lawyer that appears before the court in the conduct of the proceeding and the conduct of the advocacy is the person who will have to support the statement of claim. And in drafting the statement of claim, the solicitor needs to have a horizon to the way in which the case will be presented and run ultimately in the trial. The solicitor who is acting for the defendant or respondent will also need to have marshalled the facts and form a view about the scope of the defences. That involves thinking about the legal answers to the claim and the factual foundation for the legal answers and whether the facts give rise to equitable defences, estoppels, etc. It also involves thinking about whether the answer to the claim is an equitable set-off or gives rise to some other cross-claim. Again, the litigation lawyer who will be involved in the advocacy either in interlocutory applications in the proceeding or possibly in running the trial needs to think from the very outset about the facts and the legal issues to be agitated throughout the proceeding. It's such a good discipline to think about the right place to start. So often we find that the statement of claim is amended and amended and amended. The record in a proceeding which I took over was an 11th amended statement of claim. As a function of advocacy, you will immediately realise that when a pleading is amended 11 times, an opportunity is presented to the cross-examiner when cross-examining the principal party, giving the instructions to test why it was that the essential material facts changed so many times. It's a very bad way to begin. Like anything, if a piece of litigation starts in the wrong place, it is very likely to end up in the wrong place. These matters are particularly important threshold considerations for the solicitor who has the conduct of litigation and does so on the footing that he or she will be engaging in aspects at least of the advocacy as well. The solicitor needs to have a clear-minded view of precisely how the proceeding is framed, especially if that individual is going to walk into court and address any aspect of a challenge to the pleadings or matters related to the structure and progression of the litigation. The fourth consideration is that the first appearance before the court in these sorts of proceedings at least, is very likely to be the case management conference at which directions will be made, especially in the modern view of things. However, the case management conference in the modern world is much more than simply a matter of setting directions and rolling the arm over on consent orders. Sometimes it can be a bit like that, but by and large it's not like that. This is especially true in the federal court, which operates a docket system, and it is true for matters on the commercial list in the Supreme Court and has been true for a very long time. The fifth consideration is this. The thing that most irritates judges is a failure to prepare properly for either a case management conference or any form of interlocutory application before the court. It goes without saying that the advocate appearing at the trial needs to have undertaken intensive trial preparation so as to be entirely familiar with the record. In the absence of that, the cross-examination is not likely to be very effective at all. But at the level where we see solicitors appearing as advocates reasonably regularly, it is very important that the solicitor is very familiar with the material. For my own part, I read all the material before going into court on interlocutory applications and case management conferences. As you probably know, under the federal court docket system, each docket judge lists applications in the matters before him or her. There is no separate applications list because all of us are doing applications all the time. Generally, in these various applications, I have a view about the matters I want to ask questions of, having read the material. The judges expect the person appearing to be able to address those concerns. When a barrister appears and has to turn to the instructing solicitor, that's a problem. Sometimes a solicitor will appear instructed by another solicitor. The advocate solicitor ought not to have to turn to the instructing solicitor. My experience in this area has been that the solicitor advocates have demonstrated a capacity to be on top of the facts and legal issues arising out of those facts. As you know, in the Supreme Court, the commercial list is run something along the lines of a docket system, but otherwise there are application weeks allocated. Judges hearing applications in those weeks will not have read pretty well any of the material simply because of the lengths of the lists, and they're all condensed into 2 weeks. And you will need to be in a position to explain the nature of the application and the critical facts clearly and succinctly so that you can move the matter forward with the judge who's trying to manage a reasonably long list. The short point is that I cannot overestimate the importance of preparation, both as to the facts and the body of law raised by the questions in issue. This goes back to the fundamental point of making sure that you are entirely familiar with the applicable law, especially the recent cases. An aspect of this is making sure that you're aware of the decisions of the High Court, which have a bearing on the questions in issue in the relevant matter or application. Decisions of single judges and intermediate courts of appeal are, of course, very important, but the judges must apply the law as determined by the High Court of Australia. This year, I've had the experience in 2 matters of counsel appearing and not being aware of admittedly very recent decisions of the High Court on the very topic in issue. I accept, of course, that that can happen, but the truth of the matter is it should not happen. The next matter to think about is this. When you're asked a question by a judge, it is very important to try and answer the question as directly as possible. Don't obfuscate or beat around the bush. There will generally be an answer. The judges don't often throw up philosophical questions about the relativity of time and space or like matters. If you don't know the answer to the question because it raises a need to look at a document, simply say you need to look at an affidavit or a document. The judge will be perfectly happy to let you do that to answer the question because the judges only want an answer, that's all they want. If it involves taking instructions about a matter, simply say that. You need to take some instructions on that question. If the question involves responding to a legal proposition, try to be as focused and direct about that as you can. Don't try and hedge your bets. If you don't know the answer, say, look, I'm not sure about that, but I might need to look at that and come back to the court. And one can see what develops. The next consideration is, in my view, a very important one. These are all important, but this is a particularly important one. If you are asked questions about aspects of the factual matrix thrown up by your own material on an application, it is very important to be as accurate about your responses to the question. Try to be as precise as possible about the answers. If you are not immediately comfortable about the precise boundaries of the evidence, take the opportunity, which every judge will give you, to check and be confident about your response. It is a very undesirable thing indeed to innocently overstate the evidence, and it is an entirely unacceptable thing, of course, to consciously overstate the evidence. It is always important to remember that you can't give evidence from the bar table to fill in any gaps. Similarly, don't fall into the trap of misstating the evidence put on by another party. No doubt the representatives for the other party will be prompt in correcting any misimpression. However, remember that some parties are self-represented. On this topic, you should know that judges regularly talk about who has appeared before them, and you do not want to develop a reputation for being unreliable either by misadventure or lack of preparation, or heaven forbid, because of any deliberateness. One of the things that solicitor advocates must aspire to is a sense of respect from the judges in the conduct of the matters, in exactly the same way that barristers must aspire to winning and holding the respect of the judges in the conduct of cases. Sadly, it does not take much to make people wary. You do not want a judge looking at you with one eye closed, wondering whether the affidavits really say that or not, or whether the cases really say that or not. In a case called Ree Davis, Dixon J said that the duties and privileges of advocacy are such that their proper exercise and effective performance counsel must command the personal confidence not only of the lay and professional clients, but of other members of the bar and the judges and the profession. That proposition has been described in the authorities as a basic principle, and it is said to apply equally to solicitors who appear as advocates before the court as they do to counsel. An element of that confidence can be found in the observations of Justice Kiddo in that famous case of Zymes, where he said this: a barrister is more than his client's confident advisor and advocate, and must therefore possess more than honesty, learning and forensic ability. He is, by virtue of a long tradition, in a relationship of intimate collaboration with the judges, as well as his or her fellow members of the bar, in the high task of endeavouring to make successful the services of the law to the community. That is a delicate relationship, and it carries exceptional privileges and exceptional obligations. That statement has been found to be applicable to solicitors acting as advocates as well. Leaving aside the question of exceptional privileges for the moment, there is no doubt on the authorities that solicitors assuming the role of advocates also assume these exceptional obligations. A few years ago, I had experienced counsel appearing before me on an interlocutory application which involved a question of statutory construction in which two possibilities were open. Due to the deadlines involving timeframes under the relevant Act, the matter was urgent and had to be decided then and there, late in the afternoon. I was told by counsel that in all of that counsel's research, no authority on the section had been found or identified. I extemporised a decision adopting a particular construction of the Act, which to this day I'm sure is correct. After extemporising the decision, I took the trouble to have a look myself and found two cases on the section adopting the alternative construction. So you can imagine that if that counsel tells me, again, that particular research has failed to reveal any authorities on a relevant topic, I will be closing one eye and thinking, is that really right? And I'll be doing the research myself. The next consideration involves ExParte Applications. I'm sure you all know about these rules, and I don't really need to mention them in any detail. I'll not labour them here. But as you know, the critical matter is that you must tell the judge those things that you know that would be likely to be said by the other side if they were there. And so that is a critical element of obtaining ex parte relief. This question of full disclosure is a very important matter, and sometimes you see cases where ex parte orders have been made and their applications are made to discharge them because there weren't the relevant disclosures made. Of course, the party who's criticised for not having made the disclosures needs to know of the matters about which there was supposed to be disclosure. The next practical consideration, I think, is this. Don't drown your best points in a sea of bad points. If you're not going to win the application, or for that matter the trial, on your best points, you will not win it on your weakest points. That is true universally of all things, I think. All arguments and all controversies, no matter what the discipline. Not so long ago, I was presiding in an appeal where the notice of appeal raised 37 grounds. The first two were probably arguable, although ultimately unmeritorious. Every other ground was a challenge to a finding of fact. The submissions put on also need to be focused and succinct to make a real impact and to be of any utility to the judge. Of course, another addressee for the submissions in any proceeding is the other party to the proceedings. But that example I gave you about the appeal is a good example, because the two grounds that had some degree of validity and merit about them, but ultimately unmeritorious, it was so tedious dealing with every other ground of appeal which should never have been run at all. So it's a bad idea. Another important matter is to be sure where the critical material lies. If you are going to take the court to exhibits, to affidavits, be clear where they are and the sequence in which you want to take the court to them. It's also good to have a list which accurately reflects the filing dates of affidavits, especially if there are a sequence of affidavits from the one deponent filed across similar dates. I had an application 3 weeks ago where a party represented in the matter got totally, utterly lost in all of the affidavits, and they just had to adjourn for a while whilst the lawyer worked out the sequence of material and the right sequence of putting it to me. But that's okay. Ultimately, it is important to stand back, though, from the proceeding and ask yourself what you are trying to do. The essential thing you are trying to do is to persuade the court to your view of the matter. That will be a view about the material findings of fact and a view about the essential elements of the legal framework within which the question arises. Advocacy in so many walks of life, but especially in our walk of life, is the art of persuasion. As Murray Gleeson again has observed, the two qualities which are of real value in seeking to persuade a court to your point of view are the qualities of objectivity and selectivity. A calm and detached appreciation of the strengths and weaknesses of the advocate's own case is essential to the ability to present that case to its best advantage. Clients are usually ill-served by advocates whose passionate commitment to the cause makes them blind to the weaknesses in their own case, or perhaps even the strengths of their own case. I agree with Murray Gleeson's observation that selectivity is an essential quality if an advocate is to gain the respect of the judges. As I mentioned earlier, a barrister or a solicitor advocate who presents to the court every possible argument that can be conceived of does nothing but harm to the client. Good points are deprived of their impact by being presented in the middle of a tangle of confused and aberrant argumentation. Sensitivity in the sense of an awareness of the considerations likely to influence the judge hearing the application and tact are important qualities. Sir Owen Dixon, in an address as early as 1952, described the art of advocacy as tact in action and sensitivity. Courtesy is also a very important element in the art of persuasion. Sometimes as advocates you might end up in a situation where the judge is overbearing, but you've just got to deal with it and move through it. Hopefully that won't happen very often. Sometimes a solicitor advocate appears in circumstances where he or she has been asked to go up to court on a particular application where that solicitor does not have the carriage of the matter. If you find yourself in that situation, it is important to become as familiar as you can, as quickly as you can, with the documents and the material relevant to the application. If you need instructions, you must seek them before coming up to the court, and that will of course mean becoming familiar with the matters about which instructions might be needed. This often occurs in the context of case management conferences, and you will need to be in a position to answer questions from the bench about the matter. It's very frustrating to review a commercial matter, or any matter for that matter, and find that the person who's before you is someone who's been sent up by the team and they don't really know what the matter's about. It is also important to look at the rules of court governing procedure in whatever court you might be appearing in. I know that goes absolutely without saying, but it is important to understand the rules under which the application is brought, or the statutory provision of an act conferring power on the court, as you will have to demonstrate that the relevant integers under the rule or the statute are made out. All of this is simply a function of proper preparation. You should be familiar with the Evidence Act in Queensland, and of course you need to be familiar with the Federal Evidence Act in any matter in the federal court, or for that matter in any matter in the Supreme Court where that court's exercising federal jurisdiction, like corporations matters. The discipline of language is also very important. That is not to say that anything other than plain language should be used, but that does not mean that you should descend into coffee table conversation or slang. There is a formal way to use language and a very casual, informal way to use language. Sometimes casual phrases can be very effective in making the point, but you should not descend into that way of speech in presenting a synopsis of the facts or an exposition of the legal principle upon which you are relying. These are the practical matters that I wanted to mention, and I think my time is up. Thank you very much. Great. Yeah, do you want to stay over here?
Sure. If there's any questions around.
Sure.
Thank you very much, Justice Greenwood, for joining us tonight.
That's right.
The Society is deeply grateful for your time and commitment in delivering this lecture to the profession. Certainly had some very astute and practical observations about not only what to do, but also what not to do. I particularly like the observation early on that not to allow the client's problem to become the solicitor's problem. I think that's something we should always be borne in mind too. Now, you've got the perfect opportunity to ask His Honour some questions about advocacy and practical advocacy in general. We don't have any, I don't think, on Slido at the moment, so if you're watching via the Facebook stream, I think you can participate via Slido for any questions. Any questions from the audience in the interim? No? Well, if you want to think about one in the interim, I might have one, sure. Judge. Yep. You mentioned about the advocate or the barrister who failed to turn up any of those cases in his research. Yeah. If the opportunity arose in a non-formal manner, would it be appropriate for you to raise that with him?
I would never do that.
No?
I wouldn't do that, no. No, I mean, it's possible one could conceive of a set of circumstances where you might, but in principle, I wouldn't do that. And I don't suggest that he didn't conduct research and not find cases. I'm not suggesting that. But it's a bit disappointing that I was able to find those cases relatively quickly on the very section in question. So, yeah.
Wonderful. All right. Well, thank you very much again, Judge. No final questions from the audience? Yes. There's a microphone coming. If you just want to wait for that, please.
I've been in court before where I've seen solicitors using We Submit, and I was just wondering if that was, and sometimes the judge has sort of pulled them up on it, saying that only barristers use, we. So I was just wondering if Your Honour had an opinion on that, or if that's a sort of a big no-no.
Well, my own view is I don't think I would pull up. I don't think I would pull up a solicitor in that way. If the phrase was being used a lot, I might say something about that. But I would prefer to see someone saying in my submission, but I wouldn't make a point of arresting someone's thought processes on the footing that it's not appropriate to be using that phrase. But if it was a consistent manner of expression that was going on and on and on, I think I might say, well, perhaps it's better to put it in this way. We're trying to make courts user friendly, not places where people come in and they're frightened to front up in front of judges and frightened to ask questions and frightened that they might get a tirade. And apropos of that, and one of the things that really annoys me, I must say, is that I have a very strong view that the court is the court and the court is constituted by the judge. This whole kind of historical view about my court this and my court that, and this possessive use of the court is not anyone's court in the sense of my court this, and I don't allow this in my court, I don't allow that in my court. I can't stand it. The court is the court's constituted by a judge, the court's the institution, it's not you, and you decide cases according to law, and that's what you do. And it's not, your fiefdom for discretionary decision-making according to the way you view the way things should happen. Yes?
Following on from that, I'm just wondering if there's any particular phrases that Your Honour is particularly disagreeable to the use of. I understand different people have different styles, but is there anything that judges consistently see come up in, or phrases that are used which they find not necessarily offensive but annoying?
Well, not that I can think of offhand. But I think overuse of anecdotal phrases or colloquial phrases is not a good thing. And I don't particularly like the use of Latin phrases, actually. Now, unless they are absolutely authoritative received, res ipsa loquitur, of course. Ex parte, of course. But I don't think it helps either in oral terms or in written terms to be dropping in Latin phrases to reflect a degree of learning. If the proposition can't be put in relatively plain English terms, perhaps sophisticated, but nevertheless plain English terms, then I think there's a problem with the advocate. I remember when I was growing up, quite a long time ago, watching black and white television, there was some McFarlane Burnett came on television, and it was on the equivalent of something like a Four Corners program, but it wasn't Four Corners. But he was being interviewed on quite a long interview. It would have gone for 45 minutes, a big long interview about his research. And he explained his research to the ABC journalist, whose name I'll remember in a moment. And the journo said to him, "Oh, well, I understand that. You've explained that very well to me." And McFarlane Burnett said, and I'll never forget it, he said, well, if you can't explain your research to the cleaner when you're walking out of the building, you don't understand it yourself. And it's quite an interesting kind of approach that, if you can't succinctly explain it to a lay person, you probably don't understand it yourself, because, a lot of the legal questions that you have to address are not hugely complicated. They can be wrapped in a complexity of fact and law, but ultimately the questions often can be distilled into relatively straightforward questions. It's not binary, up or down, on or off, but it's able to be distilled, generally speaking.
Judge, I actually have two questions now from Slido. First question is, when is it appropriate to interrupt your opponent? If, for example, you believe they have mischaracterised the evidence, should you alert the court straight away?
My view is you should, if it's a mischaracterisation of the evidence, because that's an important matter, because it's predicated on the idea that the argument will continue to run on the false assumption about that fact. And so I think it's perfectly proper to stand up and say, I just want to interrupt my learned friend or my friend or whatever, because that proposition about the fact is not correct. If you look at paragraph blah blah, the position is X. So I don't have a problem with that, but I do object to opponents being interrupted just willy-nilly in the course of the argument because something might be said about a legal proposition that someone wants to contest. They get their time. People get their chance for that later on. It's not what you do. But if it is actually a misstatement of the evidence, I think that's quite an important matter.
Thank you, Judge. The second one is, how much time do you take per week to review new decisions and legislation? Do you have a system for noting significant decisions yourself?
We do. We have a very regular major library update that comes, and it comes every month. And if there's something significant it comes earlier than that. As well as that, I think all of our judges, certainly I do, are on the High Court notification list. So as soon as a judgment is being delivered, you get notification it's going to be delivered, and then you get the judgment sent to you, and you can have a look at it. And I always look at those to see what they are, and then I try to look at most of them. I must say I don't look closely at a lot of the criminal appeals, but some of them I do because they raise some quite significant questions of evidence which have broader application. So we see those, and then we get a lot of information about Intermediate Court of Appeal decisions. So, yeah, we see a lot of that. A fair bit of time is spent keeping on top of that stuff, actually.
Okay, doesn't look like there's any more.
Okay.
Right. I'd like to, again, ask everyone to show your appreciation for Mr. Justice Greenwood for coming along tonight.